now present For the Record.
Welcome to For the Record. I'm Naomi Coles. Today I'm taking you on the road to Oconomowoc for a conversation with Wisconsin Supreme Court Justice Brian Hagedorn. After a year where our highest court found itself in national headlines not once, but over and over again, Justice Hagedorn often found himself at the center of split decisions. His judicial philosophy is conservative, but his decisions have left him aligned with both sides of the bench, making him enemies in the Republican Party all the way up to President Trump. Here's our conversation looking back at a chaotic year. Justice Hagedorn, thank you so much for joining us today. I'm going to give you first a quick opportunity to kind of go over your background, talk a little bit about what got you to the Supreme Court and what your judicial philosophy is.
Yeah, well, I'm a Wisconsin guy, born and raised, and so just, had a passion for public service. Went to law school, came back, was in private practice for a bit, and then had a little path in public service. So I clerked at our Supreme Court a number of years ago, and then I had the opportunity to work at the Department of Justice for the Attorney General. Then I worked for Governor Walker as his chief legal counsel for almost 5 years. Served on the Court of Appeals for almost 4 years, and then ran and won for a seat in this court back in 2019. And so, really my passion and the reason I love what I do and why I ran is I kind of believe my job is to say what the law is. What we do at the court isn't politics. It's to apply the policy choices that the legislature has made, and whether we like them, whether we don't, but just to apply the law. And that's our role in the system. When people have disputes, we decide those disputes about the law.
Now, you're elected in 2019, but it's really been in the past year, 2020, 2021, that your role has taken a bit more prominence after what's also been a fairly chaotic year for the Supreme Court in general. They call you a swing justice. Do you like that term?
I don't call myself that. I just kind of go to work and try to do my job the same as everybody else. And yeah, I mean, the reality is we have a lot of cases that are out of the public limelight. And so I'm not always in the majority. I'm sometimes in dissent on a variety of cases. A lot of our cases are unanimous. Some of our cases are closely decided. Sometimes they're 4-3, sometimes they're 5-2, sometimes they're 6-1. The only thing I will say is I hope people who are looking to win my vote know and understand my philosophy and are making those arguments based on what I care about, which is the text of the Constitution, the text of the statutes, and that sometimes leads to outcomes that some members of the political spectrum may like, and other times leads to outcomes that the other side may like, because laws aren't only written by one side.
In about a year period, you were in the majority on every 4-3 decision, every split decision in the past year on some very major headlines, and we can talk about some of those headlines in a minute, but essentially, and that's on both what some might call the conservative side of the bench and the liberal side of the bench. How does that impact you as you're listening to oral arguments, and how do you think that impacts lawyers who are coming in to, as you mentioned, to win your vote?
Every time I've been in a 4-3 majority, it's because 3 other colleagues agreed with me. And so I can't do anything on my own. So anybody who wants to win their case needs to win a majority vote of the court. But yeah, I think people reading my work and looking at what I do know that I take the law seriously. I take judicial process seriously. And if they want to win my vote, and I hope they want to win 7 votes, on the court, not just mine, but each of my colleagues, that the arguments ought to be directed towards that. So I don't spend a lot of time thinking about that, as a practical matter. I'm just going in trying to figure out the right answer as faithfully as I can, case by case.
You call yourself an originalist, you're a textualist, and that's your philosophy. But you've also talked about how that can get complicated. These decisions aren't easy when the original text isn't clear. You've used what you call an interpretive framework, right? When language is vague. How do you keep your interpretive framework from being influenced by your personal political beliefs or the politics that people might expect you to adhere to?
Yeah, right. Well, first of all, I mean, originalism, textualism, let me just define those terms. So, textualism is the premise that typically applied to statutes, that we want to read the law and figure out what the law means, right? And this, I think, is pretty intuitive, because if one were to ask, what did you mean when you asked that question? I would pay attention to the words you said, right? Same thing when you're reading a statute. And originalism is just that same principle applied to the Constitution. We look for what the original public meaning of the words mean. Now, unquestionably, when you're dealing with language, this doesn't always mean that people who might come at it from the same approach are going to reach the same outcome. There are hard questions, and that's okay. And it's, by the way, no critique of originalism or textualism to say that. I have written about what do we do when we have language that doesn't provide all the answers. And every judge or justice understands there has to be some translation of what's there into some workable way to apply it to a case. So, for example, the Constitution protects the freedom of speech. That tells you some things, tells you a lot of things, actually, and there's some history that helps inform the content of that, but that doesn't necessarily tell you everything you need to know about every kind of case that comes before you. Same thing with the Second Amendment, same thing with, you know, all kinds of cases. So, and every judge applies that same thing. So what do I do? Well, first of all, I think whatever you're doing when you're deciding these cases always needs to be checked by how you're being faithful to the words that are there. Is this a faithful effort to apply the law that's actually there? So that I think is the main thing. In terms of how you get your own politics and policies out of it, you know, I think two of the main qualities you need as a judge, and there's lots of them, but two of the main ones are humility and courage. In both of those, there's a certain amount of humility that you have to, and maybe even self-awareness. Like, I know where my desires are, where my politics might come in, and I want to be really aware of that to make sure I can consciously put that aside and not let that affect the way that I'm going to decide a case.
Do you feel like the court might be being used by political operatives or being politicized to an extent with the cases that are coming there, but also just the heavy use of original jurisdiction in the past year?
Mm-hmm. You know, I am concerned about that. And I think, you know, most people in the judiciary understand and maybe have reason to be worried about the court being seen as merely an extension of political warfare. Now, listen, there are legitimate constitutional questions and cases that are going to come before our court, and we, you know, can and do and should take many of those kinds of cases. We have received a flood of original action petitions. And I think all of us in the court have voted to take more of those cases than we ever have in the past, in part because we've had unique circumstances where maybe there were some timeliness considerations, where some answers were probably needed. But yeah, this court should not be an extension of partisan warfare. Even though there are legitimate claims that, you know, can and are going to be made. So where you draw that line, I can't really say, but certainly it is a bipartisan affair at this point to seek to achieve through the courts, in many respects, what is difficult to achieve or not achievable through the normal political process. That's not how our founders designed the system to work. You know, we were designed to be the least dangerous branch. That's what Alexander Hamilton said in Federalist 78, which means that we were not likely to step over our bounds of authority because we weren't doing the big things that people would be worried about infringing upon their liberty. I'm not sure that's the case anymore. Most people view the court as an essential instrument and one that many of them might fear, on all different sides. And, you know, I think that's reason for the judiciary to do some self-examination on that.
Coming up after the break, a behind-the-scenes look at the opinion writing process.